Be ready? Start. The last known contested status which preceded the pending controversy until the final hearing when full relief may be granted or to compel the undoing of those acts that have been illegally done or the restoration of that which was wrongfully taken from the party complaining stop. But since the granting of such an injunction to a party who fails or would fail to establish his right at the trial may cause great injustice or irreparable harm to the party against whom it was granted, or alternatively not granting of it to a party who succeeds or would succeed may equally cause great injustice or irreparable harm. Courts have evolved certain guidelines. Stop Stancha. Mr. M. L. Verma, the learned senior advocate, primarily made following threefold submissions before us. Stop. His first submission was that the interest which was payable pursuant to the orders of this court on the extra amount taken and received by the respondent in terms of the interim orders of this court is payable till the date when extra money taken by the respondent was refunded, but instead the respondent coal company has computed the said interest only till 30/4/2008 and not till 28/6/2008 when the aforesaid extra money taken by them was actually refunded. Stop. His second submission was that the respondent company has also not paid to the applicants the entire interest that actually accrued on the fixed deposit receipt which was deposited on the account of the applicant's stock. It is next submitted by him that the writ petition of the applicants registered as writ petition number 6629 of 2005 is still pending disposal in the High Court of Judicature Bombay Nagpur bench, and the said High Court did not take up the writ petition for final disposal, as the issue with regard to excess amount over and above notified price paid prior to passing of the order dated 4/7/2005, that is from the date on which e-auction scheme came to the existence, is pending consideration before this court. Stop. He further submitted that since now this court has disposed of the said issue, there should be a direction to the concerned High Court to dispose of the aforesaid writ petition as expeditiously as possible. Stop Stancha. Mr. Anup Mishra, the learned counsel appearing for the coal company during the course of his submission, submitted that they have paid the amount which became refundable to all the claimants who are entitled to receive it, inclusive of interest in fixed deposit calculated up to 30/4/2008, as the fixed deposit receipt were time bound and therefore a fixed date was taken for calculation of the interest, which was 30/4/2008. Stop. He also submitted that whatever interest is due and payable to the applicants have already been paid, while refunding the amount due and payable to the applicants. Stop. He further submitted that the coal company has no objection if a direction is issued to the Bombay High Court Nagpur bench for early disposal of the aforesaid writ petition. Stop. According to him, the issues raised in the said writ petition would now be governed and covered by the decision of this court. Stop Stancha. While considering the aforesaid submissions in the light of pleadings of the parties, we find that the area of controversy and the dispute between the parties as highlighted in the present application lie in a very narrow compass for during the course of arguments. Mr. Mishra, learned counsel for the respondent, coal company has fairly stated that the coal company cannot have any objection to pay the interest accrued on the amount payable to be computed up to 28/6/2008 when the amount came to be actually refunded. The appellant's stop stanza. We also find jurisdiction in the claim of the applicants for the respondent. Coal company had agreed to refund the amount if later on found to be due and payable with interest till the date when it is actually refunded. Stop. In fact, that was also the intention of the order passed by this court when the interim order to that effect was passed. Stop. We may point out that though the applicant in the application stated that the amount was refunded on 25/7/2008, but however during the submissions it was agreed that the same was refunded on 28/6/2008. Stop. According to us, since the applicants were refunded the extra amount deposited by them only on 28/6/2008, they are entitled to receive interest computed and calculated up to 28/6/2008 and not till 30/4/2008, for which there is no basis at all. Stop stanza. We do not, however, propose to examine or decide the above issues here, except to observe that courts should not exceed or overlook the limitations placed by the code with reference to costs in civil litigation. Stop. In so far this case is concerned, even though the order relating to costs may not strictly be correct. Stop. We do not propose to interfere with the same in exercise of our jurisdiction under Article 136 as the order has not resulted in any injustice. Stop. It is stated that the respondents have already deposited the costs. Stop. The time for deposit of costs by the petitioner is extended at his request by a month from today. Stop. We would, however, like to refer to two aspects of the order of the High Court relating to costs. Stop. The first is whether a court, having reached a conclusion that a party deserves to be prosecuted for perjury, should let him off with what it considers to be a stiff penalty by way of costs on the ground that courts are overburdened with work. Stop. It is also to be noted that huge costs of the order of rupees 50,000 or rupees 1 lakh are normally awarded only in writ proceedings and public interest litigations and not in civil litigation, to which sections 35 and 35A are applicable. Stop stanza. The second aspect relates to the recipient of the costs. Stop. In para 38 of the impugned judgment, the High Court specifically stated that it had decided to saddle the parties with heavy costs to be paid to the state, which spends money on judicial infrastructure. Stop. Having said so, in para 39, the High Court directed that the costs should be paid to the Delhi High Court Legal Services Committee. Stop. Once the court held that costs had to be paid to the state, it should have directed payment of the costs to the state and not the High Court Legal Services Committee. Stop. No litigant should be made to feel that heavy costs are being levied in some cases by judges to recreate a corpus or expense fund for the High Court Legal Services Committee or the State Legal Services Authority. Stop. While levy of a uniform token sum as costs payable to the Legal Service Authority Committee by way of a deterrent fine in regard to non-compliance with procedural requirements delays in representation of papers, etc., may not be objectionable. Levy of huge amounts as costs in selected cases made payable to the legal service authorities may invite adverse comments and evoke hostility to legal services in general. Stop. We have also come across the cases of costs being levied and made payable to some non-party charitable organizations. Stop. The Delhi High Court Legal Services Committee, when it receives the sum of rupees 2 lakhs as costs. Stop. Over.